opportunity to introduce a little bit about the Swiss legal system. Most people who have heard about crypto valley, Switzerland, think here everything is easy and goes straight and regulation is very lean. I will show you the truth. I don't do marketing. I show you how it is. Still, Switzerland has a lot of positive aspects. We heard it before. But Switzerland has its own legal system, and this system has to be respected when you do business here.
저는 마틴 헤스이고요. 여러분들이 스위스의 법과 제도에 대해서 많이 아시지는 못하겠죠. 크립토밸리는 많이 들어봤고, 크립토밸리의 법과 제도에 대해서 좀 설명드리겠습니다.
Now the first question is, when you want to do business in crypto or digital, do we have special laws for that in Switzerland, yes or no? We don't have. No tailor-made laws. The existing rules are applied to new technologies. That's the Swiss approach. No regulation, no legislation so far. Might change, we shall see.
크립토밸리에 대해서 스위스가 좋은 법을 제도를 가지고 있다라고 다들 이야기하는데 사실 새로 암호화폐에 대한 법을 우리가 가지고 있는 것이 아닙니다. 테일러메이드해서 여기에 딱 맞게 맞추어진 맞춤 옷이 없고요. 우리는 기존의 법을 신기술이 들어갔을 때 적응을 해서 적용하는 이런 방법들을 알고 있습니다.
Swiss laws and regulations are not US style. They are rather broad and general, which allows broad room for interpretation.
스위스의 법은 어떻게 해석하느냐에 따라서 굉장히 여유가 있고 적응을 잘 할 수 있도록 되어 있습니다.
For the time being, we have no court precedents. Going to court in cryptos, which is a global business, costs a fortune. You don't know where to sue, you don't know which law applies. Anyway, the interpretation of the existing laws for the crypto world has not come to a unanimous understanding. I will go into that later.
예, 그 기존 법을 해석해서 크립토로 법률적인 것도 전부 저희가 다 같은 범주에서 하지만 사실상 여러 가지 어떤 해석을 하느냐에 대해서 100% 모든 사람이 지금 합의를 한 게 아닙니다.
We have few tailor-made provisions for the new technology. One are the famous guidelines of our supervisory authority in financial markets, FINMA, for initial coin offerings, and we have amendments for fintech companies in the Banking Act.
저희는 두 가지 법을 가지고 있는데 Guidelines for Initial Coin Offering, ICO 가이드라인이라는 법이 하나가 있고요. 그거는 핀마에서 가지고 있는 거고, 그 다음에 은행에 대해서 어떤 법적 제도적인 장치를 가지고 있느냐, 이 스위스의 중앙정부가 핀텍 컴퍼니즈라는 법을 하나 가지고 있습니다.
And we have reports by the federal government, one of 2014. This was a sort of Bible guidance for the interpretation. And there is another one expected by the end of this year. Maybe you have heard yesterday by Mr. Gerst about that. The Swiss administration is currently preparing a report. The federal government will issue that, and we hope that then we know whether Switzerland will issue laws and regulations or give a clear view on the interpretation which must be prevailing.
예, 2014년에 스위스 중앙정부가 리포트라고 합니다. 이 하나의 법을 내놨고 2018년 올해 말에 또 법과 제도는 있는데 해석을 어떻게 할지 더 정확한 보고서 리포트가 나올 것입니다.
Existing laws, an overview. And here I have to tell you, it's not Zug which is drafting the laws. Federal laws are decided, and federal laws are valid throughout the whole Switzerland. You have all these acts are public law acts, and these three here are civil law acts. They are all relevant for contract law, for securities law, and we have criminal law, and that's the whole issue about financial laws. We shall enter into that later on.
중요한 거는 카스텔리가 주크에 있다고 해서 주크시가 주가 만드는 게 아니고 중앙 정부가 여기 있는 건 다 공부해야 되겠죠. 뱅킹 액트도 있고 스탁 익스체인지 액트도 있고 콜렉티브 뭐 쭉쭉 해서 그죠. 이런 법들이 전부 조금씩 암호화폐에 적용이 됩니다.
As James Briding said, we are a bottom-up country. Of course, Canton and local laws are relevant, but in the area of Bitcoin, blockchain, digital, it's mostly taxation, which is relevant. And here too is top.
예, 오케이. 주정부, 캔톤이 주정부입니다. 주정부가 법을 만드는 건 대부분 세금 관련된 법만 만듭니다.
Now, if we go a little bit into the details, when we apply the existing laws to the digital technology, and I assume that you all know about distributed ledger, blockchain, token, coins, I don't explain that. I try to show you how Swiss law is interpreted. A banking activity is defined as accepting deposits from the public on a commercial basis. If you take deposits, you have a duty to reimburse the investors. It's a repayment obligation. Now for you.
예. 법은 우리가 흔히 뱅킹 액트 이게 가장 강력합니다. 암호화폐에서도 그죠? 은행법, 뱅킹 액티비티 이런 것이 중요하고 주로 은행들은 일반 국민으로부터 디파짓 돈을 받아가지고 상업적인 활용을 돈을 가지고 뭐 돈을 한다든가 상업적인 활용을 할 때에 그것을 바로 뱅킹 액티비티라고 저희가 정의를 내립니다. 그리고 duty to reimburse 그래서 투자자들에게 다시 혜택을 되돌려주는 이런 법들을 했고요.
Have you already translated?
Yeah, duty, no, just the
okay.
duty to
Bond
reimburse.
issues, if you have a prospectus and issue a bond, this is not a banking activity. If you invest capital to become a shareholder in a company, this is also not a banking activity. This is all possible with tokens.
본드는 또 뱅킹, 은행법이라고요? 무슨 법이라고요? 뱅킹 액티비티. 은행법하고 또 다른 법의 범주가 다르다라고 합니다.
Then acting on a commercial basis, this is very important for the token community. If you take deposits from more than 20 investors, or if you publicly advertise the willingness to accept funds from a non-limited number, not a closed circle, but a non-limited number, you are in the banking activity. If you go with your white paper out and say, collect money and you give a token, Swiss Federal Supervisory Authority, FINMA, will ask you questions.
은행법에 저촉이 되는 사람들은 20명 이상으로부터 돈을 받아서 어떤 뭐 토큰을 산다든가 아니면은 또 non-limited number 20명뿐만 아니라 정해지지 않은 수많은 사람들로부터 돈을 끌어들여서 끌어들이기 위해서 광고를 한다든가 이런 것들도 전부 법에 저촉됩니다. 스위스 정부는 허용하지 않습니다.
And then one last element which is important. Swiss law says whenever you take deposits from the public, by default, you are a bank. There are few, very limited exceptions from that. I have no time to go into that, but that's very delicate for the token issuers.
일반인들로부터 그죠? 돈을 받아가지고 그것을 또 디포짓 한다든가 누구에 보낸다든가 이런 것들은 사실은 은행 허가를 받아야만 할 수 있는 은행법에 저촉이 됩니다. 그래서 이것도 허용되지 않는 상황이다.
Now the example of ICO. If you promise to the token holders that you will get something back, to, for example, a buyback option, or you will get future profits. FINMA asks, is there a repayment duty? And if there is a repayment duty, you're a bank, you need a banking license.
그리고 내가 상대방에게 일반인들에게 돈을 이제 돈을 모아서 투자자들을 모아가지고 토큰을 산다면은 토큰을 사면은 돈이 됩니다 하고 나중에 리페이먼트를 해줄 의무를 가질 때에는 내가 또 은행법에 저촉이 되기 때문에 내가 은행의 라이선스를 받아야 됩니다. 은행만 할 수 있는 일들입니다. 개인이 못합니다.
If you use the internet, and all ICOs do that, you publish white papers and you mark your presence, this is considered public advertising and acting in a commercial capacity, which means you need a banking license. 백서를 가지고 일반인들에게 소개를 하거나 광고를 하거나 이걸 가지고 백서를 통해서 돈을 모으거나 하는 것도 은행법에 저촉되기 때문에 은행이라는 라이선스를 받고 은행이라야지만 할 수 있는 일입니다. 개인이 못합니다. And if you use third parties for marketing and sales, which is quite common nowadays, it's a good business doing that for ICOs. Then the company who is performing the ICO might be regarded as using someone to do marketing for them. Then they are also in the trap of needing a banking license. And the third party involved might be underwriter or distributor. These are both regulated activities on the Swiss law.
이것도 또 은행만 할 수 있는 건데 마케팅이나 세일즈를 할 때 제3자를 통해 가지고 내가 바빠서 다 못하니까 그죠? 다른 사람에게 좀 부탁해서 제3자를 통해서 할 때만 해도 은행 전부 은행 국민은행만 할 수 있는
얘기에 대해서 정확하게 기술을 surprised.
What happens if one of these elements is fulfilled? And you haven't asked FINMA before whether you can do such an activity and in which way. I come back to that. Then the enforcement department of FINMA intervenes, asks questions. You get questionnaires like that, 1 time, 2 times, 3 times, depending on the case. And ultimately, if the answers are not sufficient, they are liquidating the issuer of the coins.
그래서 FINMA에 enforcement department가 있습니다. 그 가가지고 뭐 구속을 한다든가 뭐 경찰 같은 이런 그 부서에서 네가 이렇게 제3자를 이용해서 뭘 했냐, 은행법에 저촉되는 일을 했냐 여러 번 물어가지고 안 되면은 ICO를 못하게 하거나 할 수도 있습니다.
When all this business with issuing tokens of coins started, people said, we are doing something which is not regulated. Because the regulator doesn't understand it and we can do what we want. So Bitcoin was created, Ether was created, that's all true, but that happened until 2014. Since then, also the world of token issues is regulated in some or the other way, because in Switzerland existing laws apply.
처음에 비트코인 만들거나 뭐 이세리움 만들 때만 해도 이런 법이 없었고요. 누가 뭐 간섭할 수도 없고 법 자체가 없었는데 2014년에 이런 법들이 만들어졌다기보다 이런 법을 적용을 합니다. 스위스에서는 기존의 법을 적용을 했기 때문에 이제 우리가 enforce 할 수도 있습니다.
One quick question. Someone was talking about no action
We
letter
come to that.
from
We come to that. We come to that.
Okay, good.
The no action letter is the result of all that what I tell you now.
Okay.
예, 그 질문 장관님
So
질문.
every company that's doing ICO in Switzerland should use the third party.
No, we recommend not using that.
Not using.
But it's big business for some companies. We recommend not using that.
Not using the third party.
Yeah.
But he probably asked the question because if I, as the token issuer do marketing and sales, then I fall under this clause.
No, you can issue your shares, your tokens, and do marketing for your own. If you do it as derivatives, you need a license as a derivative house. But if you issue your own shares, you just need a prospectus, that's all.
Okay.
And FINMA doesn't take care of prospectuses.
ICOs?
ICO? The ICO as well?
If I issue tokens, and then I go around and ask people, would you like to invest? Then we have to see whether it's done in a way that it's a banking activity, but you can avoid it. If you do the right token, it's not an activity. If you don't you must avoid having a duty to redeem. But if you just issue tokens which say you can vote, or you can keep the token and it increases in value because our business is so good and you have a secondary market, you're fine.
Okay.
So you're talking about utility tokens?
No, I'm talking about asset tokens now.
Asset tokens.
If you do the asset token properly, you get a no action letter from FINMA and you can do it.
Okay.
You must promise whatever you want to promise. Either people can vote, but only subject to the General Assembly, who has a voting right which can never be prohibited. It always goes first, it's mandatory. Or you can promise that you get a certain amount of profits. You can even have participation rights, which is a non-voting share, and all that in token form. It's all done. It's an asset token, and FINMA will approve it. You only need a prospectus.
Just to summarize, you showed a list of the applicable laws and how tough they are. And now you will tell us how you can avoid falling into these categories, right?
Exactly.
예.
That's good deal. Okay, good.
자, 일반적으로 앞에 저희가 은행법에 의해서 은행이 아니면 할 수 없는 이야기들을 쭉 했습니다. 근데 오늘 여 변호사님이 그러면 이렇게 복잡한 법을 어떻게 빠져나가서 우리가 손쉽게 할 수 있느냐를 가르쳐 드리겠습니다.
That's why we need the lawyers.
First make it complicated,
네.
get it.
That was the good thing in this invention. when they started with these tokens, they said, the lawyers don't understand, the lobbyists we don't need, the regulators we don't need. Now they need us. Here is the oversight of the Swiss fintech regulations. And I start maybe with my last comment so that you understand how Switzerland works. No special legislation for a new category of financial institutions was made, but there were just exemptions from the requirements for banks carving out. This is different in Switzerland compared to the European Union. European Union has e-money institutions, has payment institutions, and banks. So they have tailor-made financial institutions for specific purposes, which is in my eyes an advantage. Switzerland has chosen the other way, leaving everything under the Banking Act and taking out certain requirements for certain providers. Now you have for crowd lending operators.
Let's translate.
예. 그 보면은 다른 EU 나라에서는 financial institutions에서 또는 뭐 payment institution에서 다양한 그 기관을 만들어 가지고 세금을 뭐 한다든가 법이 다르고 그 나머지 전부 은행이라고 정의했지만은 우리는 반대로 스위스는 반대로 지금 맨 밑에 보면은 no special legislation for a new category of financial institutions. 그러니까 크립토를 만들거나 우리가 이렇게 하는 새로운 이런 단체를 만들 때 새로운 법을 우리는 만들지 않는다. 스위스는 오히려 더 쉽다. 그리고 앞에 쭉 이제 설명할 거예요. 이게 어떻게 우리가 그 많은 법을 피해갈 수 있느냐. 그것만 우리는 배우면 될 것 같습니다.
For fintech providers who do crowd lending, if they take the money from the borrower and keep it for a while until they shift it to the from the lender and until they shift it to the borrower, then the question arose, yeah, do they take deposits from the public? And so the holding period for funds was extended to 60 days. Now the crowdlending provider has time to collect money from various lenders and is not qualified as a bank as long as it takes the money only for 2 months on his accounts. No banking license. Then,
오케이. 우리는 요거만 알고 됩니다. 은행을 우리가 뭐 지금 ICO 하려고 은행을 새로 만들 게 아니라 은행으로 딸 게 아니라 남 투자자들로부터 받은 돈은 60일까지는 은행이라는 새로운 그 라이선스를 받지 않고도 할 수 있어요. 그래서 60일 이내에 처리를 할 수 있는 이 방법으로 ICO를 하면 됩니다.
This is specifically for the anti-money laundering case.
We come to anti-money laundering rules. They apply always. Always. That's
This is not specific for the AML.
No.
This can be applied in general.
AML applies every time.
Everywhere.
You shift money which is not used.
What's the holding period for fund and settlement for 60 days? He can hold it for 60 days?
Well, I go back historically. Taking money from the public. So if I, as a crowdlending operator, takes money from several lenders, I have to keep it on my account for some time until I get enough money to lend it to the borrower. I don't want to be the lender, I just collect the money. And this period was 7 days before this new ordinance. And so sometimes people didn't pay in the lenders within 7 days. So they were in despair. Now they have 2 months time.
So if I hold more than 60 days,
You
they
bank
regard
license.
me as a
네.
Bank, yes. And crowdfunding is a new phenomenon,
Yeah.
so that you change the regulation.
And then you have in the middle the sandbox. You can take money from the public up to 1 million Swiss franc and don't need a banking license.
이제 그 옛날에는 남의 돈을 가지고 남에게 돌려주거나 아니면 더 큰 투자를 할 때는 7일 정도밖에 가지고 없었는데 가질 수밖에 없었는데 크라우드펀딩이라는 새로운 기술이 나오면서 이제 이것을 60일로 늘려줬어요. 60일간 남의 돈을 내 구자에 넣어가지고 있어도 내가 은행에 라이선스, 은행업을 하지 않아도 되는 거고 두 번째는 지금 1 밀리언 프랑크, 스위스 프랑크는 얼마죠? 10억 정도. 10억 정도는 또 내가 은행이 아니어도 개인으로부터 투자를 받아가지고 홀딩할 수가 있습니다.
And where would you use that?
This is very good for the period we had with the e-money providers 5 years ago. For the tokens, it's too low. Token issuers want more than 1 million. But e-money providers, if they set up an app where you can make payments, and they wanted to test it with maybe one merchant, that would fit to that. But it's gone, this hype is gone.
Okay.
They can't pay interest, and they are not allowed to invest the money they get. So they use it for their own business. No license.
네, 10억 정도는 해가지고 이만이 특히 앱으로 통해 가지고 돈을 이렇게 끌어모아 가지고 할 때는 토큰을 살 때는 근데 지금은 10억 정도 갖고 ICO를 할 수가 없기 때문에 아마 이거는 많이 활용되지 않고 있습니다 지금 현재는.
And then in 2019 or 20 we will have the banking license light. 100 million deposits from the public are allowed. You have no right to do investment with this money. You just need it for your system, and you don't have the right to pay interest.
So just say it again. So this will be a new banking license light, for exactly these new transactions and business models. So you don't need a full banking license. It's a light one, but this has these limitations that here on the slide.
This would fit for ICOs because 100 million is like a huge amount, and you have much lower regulatory requirements. For a bank, usually you need 20 million capital. Here you have 300,000.
Yeah. 지금 이제 10억 정도 가지고는 ICO를 할 게 없기 때문에 최근에 바뀐 법이 1,000억까지를 보유하고 이자도 안 줘도 되고 특별하게 무슨 그 내가 받은 1,000억을 가지고 프로텍션 보호를 하는 이런 조치 뭐 보험을 든다는 이런 거 안 해도 되고 그런 법을 저희가 만들어냈습니다.
아니, 아직 만들지 않았고 앞으로
2019년 오케이 2019년 2019 you going to
When,
make this
next year or 2020. Not yet
2020
clear.
yeah.
Parliament will discuss in autumn.
autumn this year
Yeah.
autumn 오케이 올해 가을에 이런 법을 지금 10억에서 1,000억으로 넘기는 걸로 얘기하고 있습니다.
The no investment activity and the payment of interest mean that the owner of the fund should not invest other.
For example, they shouldn't go give loans. Not a typical banking activity, but they should keep the money from themselves for the purpose. If you do an ICO, you get money, but you need that money to run your business.
Only for the business.
Yeah.
And the payment of interest, they should not pay interest.
No.
Okay.
Stop
And
it.
what does that 300,000 slash
Capital of
5%,
the-
was it a 5% there? What does that mean? 5% of the
That's the minimum capital requirement of 300,000 Swiss francs or 5% of the deposits accepted.
Accept.
Oh,
Okay.
oh,
Yeah, either way.
Either way, yeah.
Okay.
5% the deposit.
So 300,000 is the
Okay.
minimum, and for the rest it might
Good.
be higher.
다른 투자 행위를 하면 안 되고 또 이자를 지급해서도 안 돼요.
Mm.
그리고 미니멈으로 33억 정도나 혹은 전체 총 수신 금액의 5% 이상의 납입이 있어야 성립이 되는 거죠, 회사가.
So Martin, the use case for the first column,
회사가 성립되는 거예요. 라이선스가 은행 라이선스.
은행 라이센스 받으려면
And-
라이트 원을.
and that sort of lending does have an interest rate associated with it, and you're saying it has a 60-day holding time.
Well, the crowd lending usually doesn't have the money which is used to grant a loan. It's simply a transmitter from the lender to the borrower.
It's not the company itself.
Okay.
It's like Indiegogo or whatever.
Yeah, or it's just P2P type
Yeah.
lending, or
But you
No,
have
but with
somebody in
middlemen.
between
Yeah.
who
yeah, well, the middleman is sitting there
Yeah.
between all of the funds. Okay, got it.
Now we come to the collective investment scheme. You might have heard that stable coins are nowadays famous. Stable coins means you have a coin which is pegged by a certain value. Nobody knows what pegging means. Really, nobody knows. But people tell, Tether, it's pegged by dollars. That's fraud, it's not true. So now, collective investment scheme applies to such schemes. That's a pool of assets raised from at least two investors independent of each other's, resulting from public advertising. Give me one more. For the purpose of collective investment.
컬렉티브 인베스트먼트 스킨이 뭐예요? 한국말로?
집합 투자?
집합 투자.
Mutual
조합
funds
투자.
in the US.
조합 투자를 할 수 있는 그 크라이테리아 그죠? 이런 그 영역이 어떤 것이냐면 하나 둘 셋 네 개가 있는데 1번이 pool of assets 그 두 명의 투자자 그러니까 적어도 두 명의 투자자가 돈을 한 곳에 모았다 그죠? 풀 한 곳에 모았을 때에 independent 그 퍼블릭 어드버타이징은
크라우드 펀딩 얘기하는 거겠지.
집합 투자 개념 구조를 가봐야 할 것 같습니다.
It's been crowdfunding too.
이제
No, no, no. You take money from various people,
어.
take it together, pool it, and then as an asset manager you decide we invest in company 1, company 2, company 3. So it's a joint investment of all the monies you get from.
It's like a fund.
Yeah.
Fund.
Mutual fund, a fund. The crowd funding is only take it for this project, then give it to him. No money here left. This is I collect money and I make investments, many different investments.
And
It's just like VC or the PF.
Yeah.
the investor, if you're in crowdfunding, if you are investing in crowdfunding, you have a right to be paid back. In fund, you just get a share in the fund. You can sell it later on. Or when the fund is liquidated, you get something.
Okay.
좀 다르죠. 크라우드 펀딩은 저희가 받으면 5% 줄게 나한테 돈 빌려줘 이러는 거고 저거는 펀드니까 조합 투자 펀드 받을 때는 뭐 이게 마이너스가 나든 이건 상관없는 거예요. 제가 그냥 받아서 조합 투자하면 내가 돈 받아서 내가 알아서 투자할게. 인베스트먼트 비교죠.
So I mean,
joint investment 그런
what
걸로.
Martin is doing right now is showing all the existing Swiss laws that have an impact with ICOs. Okay. So now we are on the second level. He's explaining what it is, and then he will say, so now how does this apply on the ICO?
지금 그 변호사님이 우리에게 스위스 로가 ICO 하는 데에 걸쳐 있는 모든 부분을 먼저 보여주고 그걸 어떻게 피해가는지 나중에 마지막에 설명합니다.
Now what is typical for fund collective investment schemes is that there is a fund manager who decides what to do with the money collected from the investors. So the profits come from the efforts of a third party and not from the efforts of the investors. That's so-called Howey test in the US. Howey test. In US, everything must be registered with the SEC because of the Howey test. If you just lean back, pay money and say, okay, I get profits from you, then it's an investment, then you are under SEC regulation. Now here in Switzerland, it's the collective investment scheme criteria. If you have an external manager who decides what to do and the profits are generated by the work of this person, then it's an investment fund.
그러니까 미국은 굉장히 복잡해서 모든 것을 내가 돈을 벌기만 하면은 SEC 레귤레이션에 연결이 되지만은 여기는 지금 현재 투자자들의 돈이 아니고 제3자로부터 얻은 그런 프로핏일 때는 이게 소속이 여기 전부 되지 않는다.
집합 투자에 속하게 되는 거죠.
그렇죠.
해당이
되는 거.
네.
예.
I'll show you an example. At the beginning of the year, the Swiss real coin was the hype. In Switzerland, everybody was talking about the Swiss real coin. It is a security token linked to a portfolio of Swiss commercial real estate. PEG. The value of the coin should be based on the portfolio.
오케이. 예를 들어서 집합 투자 또는 조합 투자일 경우에 스위스 리얼 코인은 지금 현재 스위스 커머셜 리얼 에스테이트라는 그 포트폴리오하고 연결된 시큐리티 토큰으로 디자인.
Well, it's called a security token.
예, 시큐리티 토큰으로 인정됩니다.
So the issuing company, the ICO issuer, invests in Swiss commercial real estate. The token holders bring the money and he decides which real estate he wants to buy. And the token itself is linked to the value of the portfolio. That's what they say. Now what is it really? There is no redemption, you can only liquidate the real estate portfolio. So you have just a share, the tokens, the share in this portfolio, and that's like a collective investment scheme, because the fund manager decides where to invest, and you just get a share, and the share can be traded on secondary market.
그래서 집합 투자의 예로 토큰을 만든다고 해서 펀드 매니저가 돈을 받아가지고 그것을 리얼 에스테이트 부동산하고 연결을 시켰을 때는 token should be traded on crypto exchanges, second market, secondary market 토큰을 발행할 수 있다 이런 얘기죠.
So,
계속 하는 게 나을 것
예,
같아요.
오케이 계속하는. 오케이, go ahead.
so just
이거는
I'm not a lawyer, so I'm trying always to translate it that I understand it. So there is a token secured by a portfolio of real estate. They wanted to do the ICO, and then all of a sudden the FINMA said, no, you're doing actually banking activities because Martin is showing us it's fulfilling the collective investment scheme. It's like a fund. Because no redemption, like he said, you can trade it, and it's done by a third party, the fund manager. And they did not realize, they were in TV, they were all happy to do ICO, and then FINMA said,
FINMA expressed concerns. They even ordered something. They simply said, if you do that, we feel you might be a collective investment scheme, and then you have no license, then we will liquidate you. So then they started thinking, and now postponed everything, and will come back with a collective investment scheme structure, which is a really heavy overhead. It's very expensive.
They actually paid back all the investments
Already
they received. They had to pay it back.
Oh, they have to pay back.
they paid back already.
Oh.
So even if they issue or they generate the tokens, but their activity is very, same as the general fund.
Yes,
Look,
yes.
FINMA says substance over form. You can use whatever words.
Right.
In the white paper, they said explicitly, we are not an investment fund. They said that, but FINMA said, yeah, what you do is one.
I think it's reasonable.
So the company had to pay back the money that they already collected from investors, and now waiting for new regulation.
But if they get the
ICO를
license,
다 하고
they can convert it back to a fund.
They could, but the license, like we said, is very heavy, very complex to get, a banking license.
그러니까 저게 하려고 하면
Based on what you were explaining in the previous scheme, is really what happened in the real estate bubble in the US. A lot of the insurance assets were backed by bunk real estate assets, which built up the bubble and popped, basically. So
Well,
looked very
we have at least half a dozen requests for tokens on real estate, and the obstacle is always the investment fund regulation. And when we explain that to the clients, they don't like it, but they don't go for it.
Question, you keep talking about the banking act, but is there other laws governing for the PF or the venture capital, the separate license?
No, venture capital, you can
It
raise
takes
money
license.
privately, that's easy.
So it doesn't need any banking license?
Well, also
Not because he said if you accept money from the public based on advertisement, blah blah blah, you're a bank. So if
Right,
Like-
like each bank,
Yeah.
but like a
So-
PF is, it's a private, so it's a
But
different.
if you address your needs for fresh money to FFF, family, friends and fools, just a closed circle,
Okay.
then you don't need a prospectus.
but a VC, I mean not talking about ICO, a VC who's raising money to invest in
That's fine, you don't need a banking license.
and why don't they?
Because it's equity,
It's
with
equity.
equity or loan, I mentioned that they are exempt.
In Korea, I'm running my own private equity fund. I have to get the license
For that.
In Switzerland.
venture capital also need a license.
VC capital is basically you invest, you become a shareholder with privileged rights usually, or you get grant a loan and then you have a right of repayment. That is all exempt from the banking.
You don't need a banking license in
Not that
Switzerland
much.
to be a VC.
Okay.
Because you have something in your hand, a share or a loan where you get the money back. That's why you're exempt to be a bank. So it's easier in Switzerland. Provided